to large corporation and complex litigation.
Wonderful. Thank you so much, Patrick. And so now I will move on to our general summary about Inova. So our company, Inova Human Capital Solutions, delivers expert advice and assistance to companies aiming to navigate intricate issues, streamline operations, or attain objectives. We offer an external viewpoint, introducing innovative ideas and customized strategies to boost productivity, refine decision-making, and foster expansion. And one of those pillars or viewpoints is that we want to make companies that we work with an employer of choice. That's very important to us. So with specialized expertise from professionals such as Adrian and myself, and extensive experience, we tackle a range of hurdles from crafting strategies to enhancing operations. So the agenda for today's training. By the end of the training, we hope that you will be able to elaborate on the distinction between exempt and non-exempt employees, outline the fundamental criteria for designating a position as exempt from overtime, comprehend the essential criteria for the 6 prevalent overtime exemptions, enumerate allowable deductions from the compensation of an exempt employee, identify inappropriate deductions from the pay of an exempt employee, and grasp the repercussions of improper deductions on the exempt classification. So what exactly is employee classification? I invite you right now, if you'd like, if anyone has their own definition or own experience with employee classification, to share that.
I can jump in.
Sure. Hi, Matt.
Hi, Callie. Good to see you again or hear from you again.
You too.
You know, I had an experience several years ago where a company had bought several companies in some mergers and acquisitions, and I was tasked with rewriting the job descriptions. It was about 500 job descriptions, and through that exercise, we found out that a lot of the companies that we had bought used the same titles and used the same pay bands, so to speak, but it classified the employees very differently. And it same title, one was hourly, one was salary, right? And job descriptions vastly different, and the expectations were very different. And it was a massive project. It took us over a year to rewrite all those, reclassify, get the salary bands right, notify all the employees. Had the company done a little bit better job up front in the due diligence and understood the importance of this, that wouldn't have been such a large project. And so, you know, I think to get to what your question was, you know, understanding what those are helps you to know what questions to even ask to start with. And then also understanding the importance and the litigation and the trouble you can get into. So, you know, knowing what those classifications are, knowing what the different levels are, knowing how there is some gray area, right? Some of this stuff is black and white, some of it's kind of gray, can go a very long way. Not just from straight human resources, but from a holistic company perspective.
Absolutely. Thank you so much for sharing that example, Matt. It definitely brings home the fact that this is a very important subject that we need businesses and companies to really focus on and do correctly. That's what compliance is. And so we'll go into our definition. So employee classification is the process of categorizing workers based on different factors such as job roles, hours, and employment type to ensure legal compliance and fair treatment. And so categories for this include full-time, part-time, temporary, contract, exempt, non-exempt, and interns. And so first we'll talk about exempt employees. So exempt employees are generally salaried workers that are not eligible for overtime pay. And they are exempt from specific labor law provisions such as overtime requirements. These roles often involve managerial, professional, or administrative responsibilities. But as we'll learn later on, there are very specific differences or, you know, they might not only be those responsibilities. These employees typically receive a fixed salary regardless of the number of hours worked. And then we have non-exempt employees on the other hand, and non-exempt employees are eligible for overtime pay for hours worked beyond a standard work week. That's usually 40 hours in many countries. They are subject to labor law regulations regarding minimum wage, overtime, and other protections. Non-exempt roles often include hourly workers or those engaged in routine tasks that do not fall under exempt categories. So now that we have defined those few different categories and what employee classification is, we'll move on to determining exemption status. And I'll hand this over to Adrienne.
Thank you, Callie. So when determining the exemption status of the FLSA or the Fair Labor Standards Act, we determine specific criteria and we outline that in our labor laws. And so let's review some of those key factors to determine exemption status. To be exempt from overtime, excuse me, under the FLSA, an employee generally must perform job duties consistent with exemption classification. They must be paid at least $35,568 per year, which is equivalent to $684 weekly, and receive the same compensation regardless of quantity or quality of work performed, meaning that if an employee leaves early, works longer hours, or they have substandard work, they're still paid for that salary threshold. Recently, the DOL has proposed to increase the weekly salary threshold to $1,059 per week, and that is equivalent to $55,000. Again, recently the DOL has also proposed to increase highly compensated employees up to over $147,000. Right now, it's $107,000. So again, moving forward, we need to be very mindful of the exemption status for our employees. So determining exemption status, we need to know for our employees to be exempt from the FLSA, their primary duty must be performance of exempt work. So questions for determining an employee's primary duty include, how important are their exempt duties compared to their other duties? How much time are they spending performing exempt work? Are they relatively free from direct supervision? And how does their salary compare to the wages paid to other employees for the same type of non-exempt work? Next, we're going to cover common exempt classifications. So let's start with administration exemption. To qualify for the administrative exemption, in addition to meeting the general requirements for exemption, an employee's primary duty must be the following. It must involve performing office or non-manual work directly related to the management or the general business operations of the employer or the customer. For example, employees who perform taxes or finance, accounting, or marketing, HR, just as a lot of us, and also must include the exercise of discretion in using independent judgment with respect to matters of significance. In other words, that employee must be making policies, carrying out major assignments, and more. To qualify for the executive exemption,
You're reading.
excuse me, sorry. I think someone's not on mute. To qualify for an executive exemption, in addition, again, to meeting the general requirements of just exemption, period, the employee must have a primary duty of managing the business or recognized department or subdivision of the business. The employee customarily and regularly directs the work of 2 or more full-time equivalent employees and has the authority to make or influence hiring or firing decisions in regards to personnel matters. The creative professional exemption. For individuals who qualify for the creative professional exemption, they must work in a recognized field or of artistic or creative endeavors. For example, the employee's primary responsibility would include invention, imagination, originality, or even talent. The computer employee exemption. To qualify for the computer employee exemption, the employee must be compensated again on a weekly basis of $684 weekly or $27.63 an hour. Typical positions include computer system analysis, computer programmers, technicians, or any other skilled positions in the computer industry. The learned professions exemption. The learned professions exemption status. Individuals must have a primary responsibility of performing work that requires advanced knowledge in a field of science or learning. The employee must have acquired advanced knowledge through specialized intellectual instruction. Typical positions include accountants, attorneys, and doctors. Outside sales exemption. Or outside sales team members do not have to meet the salary basis requirement. These individuals can actually make 100% commission. To qualify for the outside sales exemption status, the employee's primary duty is making sales, obtaining orders or contracts for services, or for the use of facilities for which consideration will be paid by the customer or the client. The outside sales rep is usually and regularly working outside of the location of the business. Now returning it back to Callie as she's going to be discussing permissible deductions.
Thank you, Adrienne. So under the FLSA, an exempt employee must be guaranteed a minimum amount of income each work week in which work is performed, with only a few permissible deductions allowed. Employers may deduct an exempt employee's pay for full day absences for personal reasons other than sickness or disability, full day absences due to sickness or disability if made in accordance with a sick leave plan, absences in retaliation to jury duty or serving as a witness to offset fees received, absences due to military pay only to offset payment received for such duty, penalties imposed for major safety infractions or disciplinary suspensions, partial or full day absences due to family medical leave, or partial work weeks during initial and or final weeks of employment. In relation to that, we want to talk about subjection to disciplinary action. And this is what we want employers to know and, for lack of a better word, be worried about, because we want to make sure that you're in compliance so that these things don't happen. So an employer can mandate employees to use vacation or paid time off to compensate for partial day absences. If an employee has no remaining PTO and takes a partial day off, the employer cannot make a deduction from their pay unless the absence is covered by family medical leave. However, the employee may still be subject to the company's absenteeism and discipline policies. And finally, impermissible deductions. An employer can mandate employees to use vacation or paid time off to compensate for partial day absences. If an employee has no remaining PTO and takes a partial day off, the employer cannot make a deduction from their pay unless the absence is covered, again, by family medical leave. However, the employee may still be subject to the company's absenteeism and discipline policies, as we stated in the last slide. So, impermissible deductions include the following: deductions for quality or quantity of work, partial day absences unless absence is due to family medical leave, weather-related company closures, loss or damage of employer property, and deductions for military duty or jury duty, except as to offset pay received for such duty. So with all the information that Adrian and I have just shared, we'd now like to open it up to any questions that you have that Adrian, Patrick, and myself will be able to answer for you. You can feel free to put these questions in the chat, or you can unmute yourself and ask them.
I'll go ahead. What's the most common misclassification that you see? And I'm going to direct this one specifically at Patrick. You're the one who usually deals on the back end of these things.
Apologies for that. Couldn't quite unmute myself. The most, at least in Massachusetts, it would be it's aside from what the slides that we saw, but independent contractor versus employee. That's really the one that gets employers in the most trouble. I don't know if everybody's jurisdiction is in Massachusetts or there's some Connecticut or other places around the country, but at least in Massachusetts has a three-part test, which the federal government also follows. And that's done whether the employee or whether the person is controlled by the employer, meaning they're doing the service at the direction and control of what the hiring party says. The other part of this is whether or not the employee is doing something that's outside of the scope of business. Now, that's a little confusing because that could mean something like at least in my firm, we hire a marketing manager. I give them complete control over what they're doing. The only thing I do is okay the content and they do whatever they're going to do. That's an independent contractor. Now, to say that if I hire that person as also my receptionist, so she's acting as part-time marketing manager. Oh, sorry, did I cut out?
Nope,
Okay.
you're good.
All right, good. So if I hire as a part-time marketing manager and also a receptionist, she now becomes an employee because most of her duties are part of my company, but they're part of my firm, and that's what we engage in is legal services. The other best distinguishing part would be whether the employee or hired party has their own business of their own. Does that make sense? So if they have their own LLC and you're hiring them to do a specific work that you're not controlling and that's outside of your scope of business, now you have an independent contractor relationship.
Would that be similar to having an outside vendor as opposed to an independent contractor then?
Well, the outside vendor would, if I'm thinking what you're asking, the outside vendor would be an independent contractor. Now that's assuming that that's assuming they're doing a task that's outside of the scope of your business. You're not controlling them, and they actually have their own business, even if they do it as a DBA.
Right. Okay. No, that makes sense. Thank you.
You're welcome.
Patrick, I have a question about something kind of unique that I don't think is classified as an employee, but are there any things that businesses should be worried about with volunteers? In terms of, they're obviously not classified as an employee, but what are things that we need to look out for? So, they wouldn't necessarily sign a handbook per se, but are they required to adhere to any company policy at all?
That's a great question. I've never had that posed to me before. I've never really thought about it in a volunteer context. But my guess would be that they would be considered under the dominion and control of whatever the entity is that brought them on, even if they're not being paid. So, for instance, if they got hurt, they would be able to go after the person that brought them on. There's still, yeah, they would still be under the direction and control, but they could come and go as they please.
Right. Okay.
I can probably add a little bit to that, Patrick, if it's okay.
Absolutely.
All right. In my experience in working as an outsourced CEO for some of our nonprofits, when we have a volunteer, especially if the volunteer is working in any of the financial responsibilities type of work, we have them automatically sign a volunteer affidavit that includes their responsibilities and ours.
Mm.
That way we clarify specifically, especially when it comes to the degree of specificity necessary for financial. We have to be very clear on that. Most of the NPOs and NGOs will always have their volunteers not just simply show up and start volunteering. They'll have them sign waivers just in case, in case of injury. They'll have them sign an injury waiver. They'll have them sign work-related waivers, and they'll have them sign the responsibility waivers to ensure that their actions do not adversely impact the NPO. And at least that's my experience. And that's not only in Connecticut or Massachusetts. I've done that across the country.
Awesome. See, thank you so much for your insight on that. I appreciate it.
Thank you. I learned a little bit there too. Thanks.
Does
And I have
anybody
another
else?
question. Oh, go ahead, LT.
Sorry, I
Nice.
didn't have my mic muted. I didn't ask a question.
Oh, that's okay. No worries. I did have another question just about, and Patrick, Adrian, if you want to shed any light on this, about knowing obviously when to change an employee's classification. What are some maybe hidden things that employers don't think about that could put them at risk when changing an employee's classification?
Can you be a little bit more specific? So changing classification from, from non-exempt to exempt, basically, again,
Sure.
general rule of thumb is having them using independent judgment, being able to make those choices while you are not present at the company. And I just want to make sure that's one of those, that's the question that you're asking, when to change an employee's classification.
Yes, and when you do, what are some things you should follow up on? So maybe you're changing their classification because you're changing their role. And maybe it's not that far off from their previous role. And we want to make sure that they're actually adhering to the requirements of their classification. Does that clarify for you?
Yes, absolutely. So when we want to go ahead and, of course, changing that particular employee's exemption status, the first thing and foremost is not only are we redefining job description, but we're also going to modify and send them a modified offer letter, basically informing that employee about the particular, their salary requirements, and that they will be not eligible for overtime pay. So the next thing would be to go ahead and make sure that they also sign it and ensure that they're aware of, the change in classification, and also creating a status change form to update in the records. So we have the employees signed notice that they actually note that their classification has changed from non-exempt to exempt, their change in job description, change in scope of work, of course. And then again, we just want to update the records based on the date of that employee's change in status. And of course, we want to go ahead and update their HRIS software system or their personnel records. Is that the answer that you're looking for?
Yes, it was. Yeah. Thank you so much.
Good.
Does anyone else have any additional questions? All right. Well, if not, hopefully you know where to reach us if you do think of any questions. This presentation will also be available on our YouTube channel. So if you know anyone who could use some of this information, please feel free to send it their way. Adrian, any other closing remarks?
No, Patrick Raleigh is a wonderful attorney who can assist with a lot of these questions. And again, HR is a specialty, but we always need to, for those additional questions, we always ask for legal guidance for those particular sticky situations. But again, thank you so much, everyone, for joining us. And hope, again, we're going to be having our next presentation coming up. So please stay tuned.
Thank you.
Thank you.
Thank you.
Thank you so much. Great
Thank you.
information.
Thanks, everyone.
Thank you. Take care.